Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss the importance of sending the antecedents or previous criminal activities of the accused, particularly in the stage of bail petition. So now the point is whether the police are supposed to send the antecedents or criminal activities or the cases in which he is involved to the court or not. If they fail, what is the action the court can take? So this is we are going to discuss. While giving bail, disposing the bail petition in the case of Kudoey Dohare versus State of Madhya Pradesh in MCRC number 22800 by 2022. On 30th June 2022, single judge G.S. Ahluwalia of Madhya Pradesh High Court bench at Gwalior. He stated that since the police failed to record the antecedents or failed to report the antecedents of the accused person, they can't do anything except to release him on bail in a murder case. Now here comes the importance of section, right from section 52 to 55. 55 is more relevant. 55 of the Indian Evidence Act. Please remember, normally this 55 is relating to the previous conduct. Previous conduct, yes, it can be accepted in criminal cases. Please remember, previous conduct cannot be accepted in civil cases as per section 52 of the same act, Indian Evidence Act. Alright, so very recently the court is really not happy because it has been frequently finding the police not mentioning the previous cases in which the charge sheets were filed against the accused person. Particularly in this case, the accuser was charged under section 307. You know what is 307? It is nothing but an attempt to murder. Suppose if it is results in the death, so it could have been a murder case. Just a step before death is 307. That is attempt to commit murder. Second, of course, 147, 148, 149 and 506 IPC. 147, 148 and 149. Even though in my previous I said 148 and 149 are different, but you can study them combinedly. This is nothing but any act done by a member of the unlawful assembly. Then it is called a writing or they are all punishable. Then 506, criminal intimidation, you all know well. 294 and 201. Maybe they might have tried to screen the evidence. That's why section 201 of was all cited. See, such an important case where the accused formed into an assembly and they caused a writing in which they attempted to kill one person, but their previous antecedents, the cases in which they are involved, please remember, not involved, in cases which were charged against him must be incorporated. Even though there are 4 or 5 cases against him, the police did not record or did not send any information about their previous antecedents, due to which the court has to release them on bail. Right. Now, in this connection, previously on one occasion, since these people did not send and the court found out that some other cases have been filed against him, they have sent a report to the superintendent of police. Of course, the superintendent of police stated that the concerned court constable, head constable and ASI, they have been suspended and a fine of rupees 2000 has been imposed on them. But that is not the solution to the problem. The court is finding frequently that police authorities are not mentioning about the previous cases. So therefore, they have written a letter to the DGP, to give instructions. DGP is directed to file an affidavit stating action taken report. That means whether he has duly instructed them to send the antecedents or criminal incidents of the accused person along with the so-called CD file. So this is an important issue. Normally, please remember, when discussing about section 9 or so, I think in Evidence Act 9, I told you what is conduct. Conduct is particular combination of qualities that makes a person different from others. Suppose if people say, he is an honest man, he has got impeccable integrity, he is a modest man, he doesn't pick up quarrel. So this is by way of his conduct. Conduct is nothing but reputation, conduct is disposition, conduct is the way you behave in the society, but character is different. Character is totally different. We'll discuss when the time comes. So please remember, previously also, Honorable Justices D.Y. Chandrachud and M.R. Shah, they remarked that courts, they have to take into consideration of the antecedents of the accused to find out whether he has got a bad record and whether he is likely to commit once again same offense, whether he is likely to threaten the witnesses if he comes out on bail. In the case of Shardul Singh versus State of Maharashtra, I believe. So likewise, so many cases are there. Here the important point is you have to learn that the police officer should send the antecedents to the court so that the court will give opinion whether to give bail or not. Here please remember, in civil cases, conduct is not necessary. In criminal cases, conduct is necessary. That too, please remember, I think section 53A, if I am correct. Previous bad conduct is not necessary. It is not at all relevant unless it is found in in cross-examination laga, then contradict చేయడానికి వేస్తే తప్ప previous bad character is not relevant. So this much I want to tell you. Please remember, this is the importance of section 52 to 55 of the Indian Act, and the police have got a duty to send the antecedents. Therefore, please, while writing the case diary, please, police officers, please write the cases in which they are involved. So court is concerned, not the involvement. Court is concerned the cases in which the charge sheets were filed. That is an important issue, right? Okay, I will stop here. Thank you very much.